Hello, hello, hello. Thank you, Zach, for putting me onto this. Of course, all of this is Alyssa's fault. We're back. Doesn't look like Loud. Looks like old stinky backyard. Old stinky backyard, Margaret.
All rise. Boulder Municipal Court is now in session with the Honorable Judge Jeff Cobb presiding.
You can be seated. Thank you. Give me just a moment. I gotta get our system back up and running here. I did not realize that it wasn't on, so it'll take a moment for it to warm back up. But while it is coming on, perhaps we can just get started with the basics here, and then I'll turn the video on as soon as we.
Good catch. I didn't see that.
Get everything moving. But
I was back there.
I had seen that everybody had basically uploaded, sent to the court their exhibits. So I have all of the exhibits, including yours, Ms. LeCompte, that have been sent over. Those have all been uploaded into our system, and we've labeled them as exhibits A through F. You had an A and B that you submitted quite a while ago, which were already in the system. And then Sabrina just took the initiative to label the other ones that you've sent in as C through F. And we can let you know what those are, so you'll know which ones we're talking about if it becomes an issue. But that way you'll know what you're discussing. We can show you what we've labeled as exhibits C through F. And we already had the prosecutor's exhibits that had been uploaded as well.
Oh, it's old stinky backyard.
Mr. Lau has decided to come to court, so I give him permission for him to appear by Zoom, but that it's fine either way. And then I did see that I took a moment to just glance at photos, although they hadn't been admitted as exhibits, just to get a sense of what might be the issues here today. And I'm curious as to whether there's any need for a conversation between the parties before we start. Mr. Altenberg, I don't know if you've looked at the exhibits that have been tendered and had any discussion with your code enforcement folks about that or where things stand. Does it make sense to have a conversation about resolution right now before we have a trial or not?
Your Honor, I did have the opportunity to review the photos in question, and we do intend to not have any further conversation. We believe that we can address things at trial.
Okay, good enough.
Did he change
So
shirts?
we will we'll address things as they come about. Are there any preliminary issues that need to be addressed from the prosecutor's side of things?
One quick question, Your Honor. Is it okay if we have our second witness, Mr. Strauss, who is in person today, remain outside until he is called?
That's perfectly fine. I haven't done an exclusion order excluding witnesses. Nobody's asked me to do that. So if he wants to be in the courtroom, unless there's an order, he can be. But if he's more comfortable outside the courtroom, that's fine as well.
He has expressed that, so we intend to call him when needed.
Okay, sounds good. And Ms. LeCompte, is there anything from you that you need to have addressed before we start the trial?
No, Your Honor, I'm fine.
Okay. And I think this is the other case was resolved without a trial. So I want to go through the trial process with you so you understand what this part of the proceedings are, because I don't know that you've had that experience with our court, Ms. LeCompte, and I do like to share that with people who are representing themselves. The prosecutor has the burden of proof, so it's his job to go first. He has the opportunity to give an opening statement if he'd like to. He's not required to. Similarly, you have the right to give an opening statement if you'd like. The thing I like to point out to people is just keep in mind that an opening statement is expected to be brief. It's just to be an outline or a summary of what you think the evidence will or will not show. It's not testimony. It doesn't serve the purpose of satisfying a testimony because it's not sworn under oath. So I can't consider it as evidence. But if you've watched enough law programs, you've seen the lawyers stand up and make arguments in opening statement. But after we've had an opportunity for opening statement, then the prosecutor will present witnesses. Those witnesses will testify. You'll have a chance to cross-examine those witnesses, ask them questions. Each one of them, when the prosecutor's done asking his questions, you'll be able to do that. And then when the prosecutor's done presenting his case, he's going to rest. And then it'll be your opportunity to present evidence. You can testify if you choose to do so. You cannot be forced to testify, but if you want to testify, you'll have the opportunity. You'll also have the opportunity to call witnesses to testify as well. Anyone that you call as a witness will also be subject to cross-examination, meaning that Mr. Altenberg can ask that witness questions. At the end of the trial, there'll be an opportunity for closing argument. So very similar to opening statement, closing argument is a time for the parties to make a summary of what they think the evidence has shown in the case. So Mr. Altenberg can argue that he's proved the case against you beyond a reasonable doubt. You can argue that he has not proved the charges against you beyond a reasonable doubt. And right now there are 2 charges that are pending. So there'll be perhaps arguments about 2 separate offenses, but that'll be at the end of the trial. And I do like to point out to people, and this does sometimes surprise people at the end, as they start to do their closing argument, they get an objection from the prosecutor because they're talking about something that hasn't been introduced as evidence. The only thing you can comment on is the evidence that's been presented or that during the trial. You can't add new evidence. So if this is a red light case, you couldn't stand up in closing argument and say, Your Honor, the light was green when I entered, if you hadn't actually said that during trial under oath. So just keep that in mind. What I can consider as far as evidence goes has to be either sworn testimony from a witness or the exhibits that get introduced. If you have questions during the trial, feel free to ask them. We've been involved in this long enough, so I hope you feel comfortable that I will try to help you answer legal questions if I'm able to do so. I can't give you legal advice, but if there's a procedural issue, you're not sure what the magic words are to get an exhibit introduced, I'm not going to try to keep you from getting information that I want to be able to see from getting admitted into court. Does that make sense to you?
Yes, I do have one question.
Sure.
When you said that I may or may not testify if I wish,
That's right.
is the statement that I make during when I get a chance to present the defendant's side of the case, is that considered testimony?
If it's your opening statement, it's not. If it's sworn testimony, if you swear under oath that you're going to testify, then that is evidence that I can consider. But if you give an opening statement and say this, and this, it's nothing I can consider until I have evidence to support it.
Okay.
Does that make sense?
Yes, it does.
Okay. All right. Any other questions?
I'll ask them if I have to think.
That's fine. And don't be afraid to ask. I'll try to answer questions if I can. Right now, I'm going to try to get myself onto the Zoom video. That may take a second or two here.
I told you it was the greatest case of all time. Ah.
Okay, I think we're ready to proceed. So, Mr. Altenberg, let's turn to you. Do you have an opening statement?
People would like to waive opening statement, Your Honor.
Okay, thank you for that, Mr. Altenberg.
Furthermore, Your Honor, permission to remain seated for the purpose of the trial.
That's perfectly fine. And you can stay seated too. You don't need to stand at the lectern, whatever's more comfortable for you, Ms. LeCompte. And do you have an opening statement that you'd like to give?
No, I don't.
Okay, then we can start with the evidence presentation. Mr. Altenberg, your first witness.
Yes, Your Honor. The people would like to call Officer Benjamin Cochran, please.
All right, Officer Cochran, if you'll come forward. When you get into the witness area, if you'll raise your right hand, I'll swear you in. Do Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, officer. Go ahead and have a seat. And whenever you're ready, Mr. Altenberg.
Thank you, Your Honor. Officer Cochran, can you please state your name and spell your last name for the record, please?
Yes, it's Benjamin Cochran, Cochran.
Officer Cochran, what is your occupation?
I'm a code enforcement officer for the Boulder Police Department.
And Officer Cochran, how long have you been in your current role?
I've been employed in this position since July of 2019, so just a couple weeks shy of 6 years.
Do you have any prior law enforcement experience after or before this?
No, this is my first position within government law enforcement.
Officer Cochran, can you briefly describe your job duties and responsibilities as a code enforcement officer for the city of Boulder?
As code enforcement officer, I respond to complaints or requests for service, and I perform proactive enforcement of the city's property maintenance codes. Generally, we respond to issues regarding trash storage, accumulation of trash, in the winter, unshoveled sidewalks. Occasionally, we handle smoke and enforcement and use of pesticides, but generally the kind of overview is that we do property maintenance and property nuisance codes.
Officer Cochran, were you on duty on March 5th, 2025?
I was.
And on March 5th, 2025, did you respond to any incidents or complaints?
I did.
Officer Cochran, where did you respond to?
I responded to several calls that day, but on that specific day, I remember that I did respond to the property at 290 Pawnee Drive.
And is that location 290 Pawnee Drive in the city and county of Boulder, state of Colorado?
Yes, it is.
What was the basis of the complaint that you were responding to?
So on that particular day, we had received a complaint that there was a large accumulation of loose property, generally described as, it was reported to us as junk, that had accumulated on the property and had been there for some time, both in the front setback of the property, and then that there had been more accumulation of items in the rear yard of the property as well.
And when you went to 290 Pawnee, what did you observe?
When I responded to 290 Pawnee, I did observe that there was loose property, junk items, outdoor items, indoor items that were stored on the driveway area. And additionally, there were some items that were in the front yard of the property, as well as some items in the north yard of the property along Sioux Drive.
This loose property, was this visible from the public street?
Yes, it was.
Did you take any photos during the time that you were responding to the complaint at 290 Pawnee Drive on March 5th, 2025?
Yes, I did.
Show us the pics.
What is depicted in these photos?
The photos depict the exterior of the property, the yards, the various setbacks of the property. There were photos taken of the driveway area facing east towards the garage of the property. And then additionally, there were photos taken of the front yard and the kind of front entryway of the property.
Your Honor, permission to show Officer Cochran what he marked as People's Exhibits 1, 2, 3, and 4. I intend to show each exhibit at one at a time and lay the foundation to move them to evidence at the same time.
That sounds good. Go ahead.
May it be.
You can do it, or you can ask our clerk to do it, whichever preference you'd have.
For the purposes of recording purposes, can we have the court clerk possibly do that?
That's fine.
So maybe easier for Officer Cochran as well to observe the photos.
So do you want to see Exhibit 1 first? Is that your
Yes,
preference?
please.
Okay, so Sabrina, are you able to pull up Exhibit 1 for the parties here? Looks like everybody can see that. Is that correct? Ms. LeCompte, you're able to see that?
Yes, I am.
Okay.
Could I know what the numbers of these are as they're?
Yes, this is Exhibit 1. People's Exhibit 1.
Exhibit 1.
And can you move on to?
And it's
exhibit two,
awful.
please?
Like what the exhibit number is doesn't matter. If that's what your house looks like, you lose. It does. It looks worse than it did, and it looked bad.
I don't. Oh, it'll show me. My apologies. I had to do it separately.
Can you please move to exhibit 3, please?
And this is People's Exhibit 3.
Lastly, can you move to exhibit 4, please?
And that's Exhibit 4.
Officer Cochran, what are these?
These are photos depicting the driveway area and the front entry area, kind of the covered front patio of the house at 290 Pawnee Drive.
Do you recognize these photos at all?
Yes, I do.
How do you recognize these photos?
These are photos that were taken by myself.
Were they taken by yourself on March 5th, 2025?
Yes, they were.
Would you say that these photos are a fair and accurate representation of the property of 290 Pawnee Drive on March 5th, 2025?
Yes, they are.
Your Honor, people would like to move for the admission of exhibits 1, 2, 3, and 4 into evidence, please.
Ms. LeCompte, do you have any objection to the admission of those 4 exhibits?
No.
Okay, exhibits 1 through 4 will be admitted.
Can you please move to exhibit 1, please? Officer Cochran, what is depicted in the photo labeled as People Exhibit 1?
This is a photo taken from the Pawnee Drive side of the property, looking towards east towards the garage of the property. In the photo, there is an accumulation of various loose items of property, including storage totes, vehicle maintenance equipment, appliances, boxes. Some of it just appears to be scrap metal, but it's a various assortment of loose items.
Can we scroll up in the photo, please? What does the text information on the top right of the photo represent?
That is a superimposed text over the photo that indicates the date and time that the photo was taken.
And what kind of items are pictured in this photo?
Again, it's mostly there's appliances, vehicle, I'd say, mechanic type equipment. There's vehicle ramps on the right side of the photo, storage totes. There appears to be a blue barrel for storing liquid of some kind, presumably. But again, it's just an accumulation of various loose items.
Would you describe these items as trash, recyclables, or compostables?
Yes, I would classify them primarily as trash.
And are these being stored in any sort of container?
No, the items pictured are not stored in closed containers.
Does it appear that any of these items, it does sound from your testimony that some of them do, but just does it appear that any of these items are vehicle parts, furniture, household appliances, household items?
Yes, there are several of each of those photos.
And are there any items larger than 3 feet in length, width, or breadth?
Yes.
Are these items on the property of 290 Pawnee?
Yes, they are. They are stored in the driveway area of the property.
And are these items hidden in any way?
No, this particular photo was taken from the public right-of-way adjacent to the property.
And would you say these items are stored in any organized way?
No, not in my opinion.
Can you move to exhibit number 2, please? And what is depicted in this photo? What does this exhibit number 2?
This is a photo of the left side of the driveway. If you're looking at the property, it's kind of taken facing northeast. But in the photo, there are more loose items accumulated on the driveway, as well as the front covered patio area of the property.
And the text in the top right of the photo, does that indicate the same information as noted in exhibit 1?
Yes, it was the date and time that the photo was taken.
And similarly, would you describe these items as trash, recyclables, or compostables?
Yes, I would.
And similar to as in exhibit 1, does it appear that any of these items are vehicle parts, furniture, household appliances, household items?
Yes.
And are there any items that you see here that are larger than 3 feet more in length, width, or breadth?
Yes, there are some items that are larger than that 3 feet measurement.
And these items are still on the property of 290 Pawnee?
As of, are you?
Correction. Are these items on March 5th, 2025, are these items on the property of 290 Pawnee?
Yes.
And are these items in any way hidden from the public view?
No, once again, this photo was taken from the public right-of-way adjacent to the property.
And are these items stored in any organized way?
Not that I can tell.
Can we move to exhibit 3, please? What is depicted in the photo labeled as People's Exhibit 3?
This is a photo taken to the left of the front door of 290 Pawnee, facing north towards Sioux Drive.
And does the text information on top right indicate the same information as noted as in People's Exhibit number 1 and 2?
Yes.
What kind of items are pictured in this photo?
There are several cardboard boxes. There are electronics, household appliances, containers that would generally be used for storing chemicals of certain kinds. Just sort of a loose assortment of various types of items.
And would you say that these items are on 290 Pawnee?
Yes, they are.
And are these items visible to the public?
Yes, this particular viewpoint was taken from being directly in front of the front door, but they are visible if standing on the public right of way.
And are these items organized in any way?
No, they're not.
Thank you. Can we move to exhibit 4, please? What is depicted in the photo labeled as People's Exhibit number 4?
This is a photo taken of the right side of the front entryway of 290 Pawnee, looking south towards the driveway area of the property.
And similarly to the previous photos, does the text in the upper right-hand portion of the photo represent the same information as noted as in exhibits 1, 2, 3?
Yes, they do.
What kind of items do you see in this photo?
There are, again, chemicals of various kinds, cardboard boxes. There appears to be several bottles of what appears to be some kind of cooking spray, perhaps, but mostly various different kinds of household items, and including tools of different kinds.
Would you describe what you see here as trash, recyclables, or compostables?
Yes, I would classify the majority of this as trash.
And are these items on the property of 290 Pawnee?
Yes, they are.
And are these items hidden from public view?
No, once again, this particular perspective is from directly in front of the front door, but the majority of these items are visible from the public right of way, or they were visible from the public right of way on March 5th.
And are these items stored in any organized way?
Not that I can tell.
Officer Cochran, while you were responding to the complaint at the property of 290 Pawnee, did you have any interaction with anyone aside from the cited individual?
Yes, I did.
Who did you interact with?
While I was inspecting the property and investigating for potential violations, I was contacted, or I contacted neighbors of the property at 290 Pawnee.
And who did they identify themselves as?
They identified themselves as being the neighbors directly to the east of them on Sioux Drive.
And do you know what the address of that property is?
I believe the address would be 4630 Sioux Drive. It's the first property directly adjacent of 290 Pawnee on Sioux Drive.
So does 4630 Sioux Drive and 290 Pawnee Drive abut each other?
Yes, they do.
Did the occupant of 4630 Sioux Drive permit you to enter their property?
Yes, they did. I spoke with them briefly and explained why we were there, and they allowed me onto their property to inspect further.
And did you go into their backyard?
Yes, I did.
With their permission?
Yes, I did.
What did you observe when you were in the backyard of 4630 Sioux Drive?
From the rear porch area of that property, I was able to observe the rear yard of 290 Pawnee. In the rear yard, there was a large accumulation of various items that were visible from 4630 Sioux Drive.
Did you take any photos while you were in the backyard of 4630 Sioux Drive?
Yes, I did.
And what is depicted in these photos?
The photos depicted the loose property that was stored in the rear yard of 290 Pawnee. Among the items were bicycles, household appliances, car parts, storage totes, shelving, just kind of again, a various kind of assortment of what I would categorize mostly as household items.
Your Honor, can we show the Officer Cochran what has been marked as People's Exhibit number 5, please, in a similar manner to how we've been able to show them?
Sure. Sabrina can pull that up for you.
Thank you. Officer Cochran, what is this?
This is a photo that was taken by myself from the rear patio area of the adjacent property at 4630 Sioux Drive.
So you recognize this photo?
Yes, I did.
And how do you recognize this photo again?
This is a photo taken by myself.
And is this photo a fair or accurate representation of the backyard of 290 Pawnee on March 5th, 2025?
Yes, it is.
Your Honor, the people would move for the admission of Exhibit number 5 into evidence, please.
Ms. LeCompte, any objection to Exhibit 5?
I have some objections. Yes, I do.
Do you want to share what your legal objection is to the admission? That's the only thing I'm questioning right now, is just whether you object to the admissibility of that.
I'm not sure whether this is a legal argument, Judge, but I believe that this picture was taken under duress of the neighbors, and therefore that they were scared. And therefore, I think it's not really a fair, it's not fair to show this, because in order to get this picture, excuse me, Mr. Cochran, Officer Cochran had to be up on the neighbor's back porch because it's basically, this is not visible from the street or anything.
I did not see that coming. I expected stupid, but that is a special kind of stupid I didn't even anticipate. The picture was taken under duress. The picture was taken by the police officer. I don't believe he was under duress.
Other place except from that area.
I'm going to admit Exhibit 5. It's admissible. The argument that you've raised, I don't have any evidence to support that it was unlawfully obtained. The officers testified that he had permission from the resident at 4630 Sioux Drive to go on the property. I don't have any evidence to the contrary on that. So I'm going to admit Exhibit 5. You can continue, Mr. Albert.
Thank you, Your Honor. What is depicted in the photo labeled People's Exhibit number 5?
This is a photo showing the items which are being stored in the rear yard of 290 Pawnee. Among the items, again, are several household or a large number of household items. There are various appliances, electronics, there are vehicle parts, various types of shelving. There's bicycles, just kind of a general accumulation of items.
And does the text information on the top right of this photo represent the same information as you noted in the previous exhibits?
Yes.
Now, you've already provided us with a list of items that you've seen here. Would you describe these items as trash, recyclables, or compostables?
Yes, there are items that would be classified as trash. There are also several items which inherently would not necessarily be trash, but the manner in which they're stored outdoors when they're intended to be indoor items would render them as trash.
And when you mention items that are indoor items, would this include vehicle parts, furniture, household appliances, or household items?
Yes.
And are there any of these items larger than 3 feet or more in length with their breadth?
Yes, there are.
And are these items stored in any sort of container?
No, they are not.
Are these items on the property of 290 Pawnee?
Yes, they are.
And are these items organized in any way?
To my knowledge, no, there doesn't appear to be any sort of specific organization system.
After you left the property of 4630 Sioux Drive, did you contact the resident of 290 Pawnee Drive?
Yes, I did.
Did you speak to them face to face?
I did.
Did they identify themselves to you?
I believe so. I had also known the resident from previous interactions. So if they did not identify themselves specifically, I was aware of who they were.
And is this individual an occupant of the property of 290 Pawnee?
Yes.
Is that individual the occupant, as you mentioned, of 290 Pawnee? Are they in the courtroom today?
Yes.
Can you identify them with a description of an article of their clothing they're wearing?
It would be the defendant wearing a black jacket.
There is a couple people in this room wearing a darker jacket. Can you give us another article of clothing?
The defendant wearing a blue shirt.
Your Honor, let the record, subject to cross-examination, reflect that the witness has identified Ms. LeCompte as the defendant.
The record will so reflect, subject to cross-examination.
Your Honor,
Mr. Lau,
identify me. I
sir,
wasn't there.
Sir, you do not have the opportunity to speak unless you're called forward as a witness. So you may have an opportunity to testify, but if you'll just remain quiet until you're called.
Is that Lau piping up?
When you addressed Ms. LeCompte, what did she tell you about the items that were on her property?
She had informed me that the items were currently that her and her associate, Mr. Lau, had been working to remove items which were considered trash. They were in the process of organizing and removing the items from the property.
And did Ms. LeCompte ever give you a date or a time in which she intended to have them removed by?
I don't recall a specific time or date, but she said that she was actively working on removing the items subject to some physical abilities which were hindering their efforts.
Been at
to
that
remove
8
the
months. Mm-hmm.
And you noted that you've had previous interactions with Ms. LeCompte before, correct?
Yes.
Did those interactions involve you going to 290 Pawnee?
Yes, they did.
Did those interactions involve items similar to those that you've seen today?
Yes, they did.
Thank you, Officer Cochran. No further questions.
Thank you, Mr. Altenberg. Ms. LeCompte, do you have any questions for Officer Cochran?
Is this the one that there's a cross-examination time?
That's right.
Okay. Good morning, how are you? Officer Cochran, had there been any prior complaints made about 290 Pawnee?
Yes, there have been requests for service for us to inspect the property.
Do you know who made those requests and what kinds of people made those requests?
Um,
Your Honor, we're going to object to that if possible.
What's the objection?
We don't believe that the type of people or the individuals who are subject to the complaint is relevant to the actual items that are on the property.
I'd very much like to argue that it is a relevant question.
Go ahead and tell me why it's relevant to the determination I have to make, which I'll just point out is I have to decide whether or not there was a violation of the ordinance, the two ordinances that have been alleged. And so
I understand that, Your Honor, but the Officer Cochran and actually the former prosecutor have told me in the past that many neighbors and passersby made comments about this, and I have repeatedly tried to find out who they were, who these people were, and have not been told that. And if there is no evidence or substantiating other than the complaint that is made by Adia Lovey and Jason Strauss, then that is simply hearsay evidence and it's not admissible.
if he were to try to offer what those people said to him, that would be hearsay. I agree with that, if they weren't here to testify.
Yeah.
But it's, and so he doesn't have the right, and I would sustain an objection if he were to try to testify about what those people had said, because they're not here and subject to cross-examination. But that doesn't explain why your question of him, of who those people were, is relevant to the determination I have to make.
I would just simply like to know that other than random passersby and random neighbors, without any statements from such people, or without any kind of their presence here in court to testify, does constitute at least a considerable lack of substantial evidence that there actually have been many complaints.
No, it doesn't.
I'm going to sustain the objection based on what I've heard from both parties. The issue for the court is whether or not on March 5th of 2025, there were violations of the ordinances that have been alleged. The amount of evidence that the prosecution provides is subject to argument and closing argument as to whether that meets the burden of proving it beyond a reasonable doubt. But it is up to the prosecution to determine what evidence that they are going to provide. And if they elect to simply provide the officer to testify and the exhibits, they have the authority to do that. So I'm going to sustain the objection because I don't think it's likely to lead to the admissibility or the discovery of admissible evidence. So the objection is sustained. You can continue with other questions if you have.
Can you tell me who told you to write a ticket for me or against my property, Officer Cochran?
Now, we're going to object to that as well for hearsay purposes. She's asking the officer to tell her who told him to write a complaint.
Do you want to respond to that objection, Ms. LeCompte?
I think it's relevant because I am interested in whether the orders are coming from code enforcement itself or from some other place.
And why would that be relevant to the determination I have to make?
It is relevant because of the continued campaign that the prior prosecutor has maintained against me and my property and my partner over the last.
Oh, yes, she's getting railroaded. She's getting railroaded. This has nothing to do with the fact that their house is trashed. And you can go out there anytime, any day, and take a picture of the mess that they have. But no, it has nothing to do with that. It's just some crazy prosecutor who's got it out for her. Oh, please.
These many months.
I'm going to overrule the objection with respect to the answer to that question. I'm not going to allow the witness to testify about substantial conversations that he may have had with that individual, because it may be protected under attorney work product or some other client representation. So he may not be able to disclose the content of those conversations other than he was directed by a certain person to issue the citation. So you can answer that question if you know the answer to it.
At that point in time, when I responded to the property, I was personally prepared to issue a summons. The only conference that I had was I confirmed with the city attorney's office that a ticket would be valid for this violation due to the accumulation of items that were present in the front yard as well as items that were present in the rear yard as well.
You can ask other questions from there if you choose.
I have no more questions.
Okay. Any redirect?
Yes, Officer Cochran, when you respond to a complaint, why do you respond to complaints?
We respond typically so that if there are, neighbors or, persons within the city who have situations or potential code violations that they would like resolved, generally they're for health and safety purposes. So we make it a point to respond to complaints to make sure that specific concerns from, citizens or persons within the city, that their concerns are addressed, whether they're actual violations or not. We make it a point to at least inspect them and make a determination from there if they constitute a code violation.
Thank you. No more questions, Ron.
Any questions based on that question?
Yes. Can you tell me whether the adjacent neighbor specifically made a complaint that led you to be there on March 5th?
As far as I'm aware, it was not the neighbor immediately adjacent at 4630 Sioux Drive who had submitted the request for us to make an inspection. I did contact them once I was at the property, just by happenstance, but I do not believe that they were the ones who submitted the original complaint, which spurred us to visit the property on that day at that time.
Can you explain what you mean by happenstance, that you met them by happenstance?
I believe on that day, while I was there at 290 Pawnee inspecting the property, the neighbors at 4630 Sioux Drive had returned home after I believe they were running errands of some kind. And I just happened to observe them and they observed me while I was doing my inspection.
So you initiated the contact with Mr. Strauss and Ms. Levy?
I don't recall specifically who made the initial contact, but I believe it was, I observed them arrive home. We kind of greeted each other and I just explained why I was there at the property once again. And that's when they gave me additional information and subsequently invited me onto the property for further inspection.
So would it be correct to say that neither Mr. Strauss or Ms. Levy actually filed a complaint against 290 that you were responding to?
Your Honor, we're going to object to that once more. I don't understand why, people don't understand why questions pertaining to 4630 Sioux Drive and a possible complaint has to deal with the actual evidence of items on the property of 290 Pawnee Drive, especially involving the allegation of, after the witnessing question has already stated that he's confirmed that it's not them that's originally put the complaint.
So it sounds like you're saying you object to it as under relevancy grounds.
Yes.
Okay, so the objection is it's not relevant who initiated the complaint. Do you want to respond to that?
The response to that, what I am concerned about is that Officer Cochran has already described what I will testify to later, that we were well in the process of trying to remediate all of these different concerns in my yard, and therefore to
No, you weren't.
initiate further contact with neighbors to generate a complaint would be something that I would find objectionable.
Okay, so the objection is sustained. I'm not sure that I shouldn't say I'm not sure. It's not relevant as to how the officer came to the property for the court's determination. I'm going to sustain the objection. But if you have other questions that are based on that initial question from Mr. Altenberg during redirect, you could ask.
No, sir.
Officer, you can step down then. And do we need Officer Cochran to remain just in case there's other testimony he might need to call in your rebuttal case? I'll leave it to your discretion, Mr. Altenberg.
No, Your Honor.
All right, so you're okay with him leaving?
Yes.
Your Honor, because.
Hold on for a moment. Again, you're not a witness or a party here, Mr. Lau, so you can't address the court. I know you want to, but you do.
He testified about my presence. So I believe I have the right to question or cross him.
No, you do not. No, you do not. You're not a party to the case.
You don't,
So let me make
jackass.
it clear.
Shut up.
He may have testified and your name may have come up, and certainly if you're called as a witness, you can testify about your involvement with the case, but you don't have any standing to participate in the proceedings otherwise.
My apology, Your Honor.
That's okay. You can step down. And if I'm hearing correctly from you, Mr. Altenberg, you have no objection to him being released from his subpoena at this time.
We do not.
Ms. LeCompte, did you anticipate recalling Officer Cochran?
No, I don't.
All right, you're released from your subpoena, officer. Thank you. All right, any other witnesses for the people?
Yes, Your Honor. I would like to call Mr. Jason Strauss, who's currently,
You can step out and invite him in or have Ms. Keller invite him in.
Your Honor, people's witness is currently running to the restroom right now, so we apologize for the delay.
All right, we could take a couple minute recess, just allow people to use the facilities if they need to, and we'll start back up here at 3:25. So we'll just wait a couple minutes. But if you need to step out, Sabrina, you've been on the bench for quite a while prior to this, so if you need to step out, feel free, and we'll come back in at 3:25 and you can go off the record for just. All right, sir, if you're Mr. Strauss, if you'll come forward here, I'll swear you in as a witness. All the way up to the witness stand, if you will, and just go ahead and have a seat right there. Once you get there, I'll have you raise your right hand for me, sir. All right, good afternoon. If you will, raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you, sir. Go ahead. Whenever you're ready, Mr. Altenberg.
Thank you. Hello, Mr. Strauss. Can you please state your name and spell your last name for the record, please?
Jason Strauss, Strauss.
Mr. Strauss, what is your address?
4630 Sioux Drive.
And how long have you resided at 4630 Sioux Drive?
Just coming up on 2 years.
So on March 5th, 2025, were you residing at 4630 Sioux Drive?
Yes.
Do you know what address abuts your westernmost portion of your property?
Yes. 290 Pawnee Drive.
And who resides that property?
Ms. LeCompte and Mr. Lau.
On March 5th, 2025, did you have any contact with a code enforcement officer?
Yes.
And did you give them permission to enter your property?
Yes.
Did you give the officer permission to take photos while on your property?
Yes.
And what did the officer take a photo of?
The officer came to our backyard, took a picture, I believe, from our deck overlooking into 290 Pawnee.
Can we show the witness exhibit number 5, please? That's already been admitted into evidence. Mr. Rouse, do you recognize this photo?
Yes, this is the photo from the deck in our backyard.
And how do you recognize this photo?
This is the view from my yard, from my deck, from my kitchen window.
And do you remember seeing these items on March 5th, 2025?
I do. Many of them have been there for a while and were there. Yeah, I've been there for a while.
And what kind of items do you see in this photo?
A lot of different things. It's like storage racks, buckets, bikes. I think some of the more concerning things, it looks like a lot of pieces of machinery, kitchen appliances, motors, cables. And I think you can make out quite a few barrels and buckets which contain, I'm not sure what. And there's a cooler I can see. Yeah, I don't know how long you want the list I can see here, but a lot of different stuff.
It's okay. On March 5th, 2025, were there any items in Ms. LaComp's backyard that aren't visible in this photo due to the angle?
I think this picture shows quite a lot. I think it does extend, both behind the fence to the tree. I would say the other big one is just barrels, enormous barrels of liquids, I guess, is probably the biggest one. You can't see behind this tree. Like you can't see it. Sure, yeah.
And how tall is the fence in that yard?
6 or 7 feet, I think.
And can you see the pile of loose property from over the fence?
Absolutely. Yeah, you can see it. I mean, our deck is raised a bit where you can see it, but you can clearly see it, like I said, from the yard, from our kitchen windows.
From your time living at 4630 Sioux Drive, do you know whether any of these items were being conserved for later use or for collection?
I'm not sure. It's, like I said, a lot of it's been there for a while. I think I've seen something move, but I'm not sure.
And when you say moved, do you mean moved on, still on the property?
Both on and off the property.
Does this pile of loose property appear to be a fire risk?
I think so.
Why do you think it's would be a fire risk?
I mean, we get high winds here, which is obviously there's a lot of loose property. But we are nervous about stuff flying into our yard. There is also, not in this picture, but a pretty sizable pile of wood. And I'm also nervous about the ability to get on and off the property. For us, for fire people, such a thing.
And does this pile of loose property actively harbor any pests, rodents, or wildlife?
We, for the first time sort of recently, have seen rats and mice in our yard, which we hadn't seen before. We have seen raccoon recently on the fence. And then the other one is, like I mentioned, we've seen kind of by the nature of the layout, just kind of standing water, which I think harbors mosquitoes in our kind of dry climate.
And do you recall there being any existence of odors that had been coming from 290 Pawnee on or about around March 5th, 2025?
I don't recall any specific odors on March 5th.
Okay. But the pile that you see here that you've testified to as being something that's been there for an extensive period of time, has there been any odors that have wafted from that pile?
Yeah, I think we've smelled some odors. It's tough for us to pinpoint exactly where they're coming
It's stinky
Has
and
Ms.
noxious,
LaCompte
just
ever
say it.
expressed any worries to you about the dangers that you've mentioned?
I don't believe so.
And aside from the backyard that you see in Exhibit 5, do you have any personal knowledge of any other loose property that exists on Ms. LaCompte's property on or about March 5th, 2025?
There is
A couple loose stools up front.
in the driveway always quite a bit of property,
They really are.
as well as, yeah, as in the driveway. It's quite a bit. I think, like I mentioned, there's quite a sizable pile of wood in the front property. There are some of these rather large storage containers in the front yard. Those I think have been there since then.
And how do you know that those exist on March 5th or around that time?
I walk my dog in that area almost every day, if not several times a day. Walk my son to our friend's house and our nanny down Pawnee, like once or twice a day. So I'm there all the time.
And you noted that some of these containers stored liquids, correct?
Correct.
Do they all store water?
I'm not sure. It's an enormous gallon. It's thousands of gallons by my estimation. They're not particularly ordered. They're kind of stacked, lopsided and whatnot. Most of them are opaque. Some of them are transparent, but I couldn't quite tell what's in them.
And are they visible to the public?
Yes, I believe so. They were as of yesterday.
Prior to March 5th, 2025, how long has Ms. LaCompte's backyard looked like in Exhibit 5?
I can recall the day. It's February 22nd. It's when we came home from the hospital with our second son. So on that particular day, we were excited to come home. The property front yard was being cleaned up, which we appreciated, but a lot of it seemed to move from the front yard to the backyard on that day.
So from your testimony, did Ms. LaCompte just move the items from her property from one side to the other?
I don't have an inventory, but it appears that a lot.
I have an objection.
Go ahead and state the objection.
It's conjecture.
So the legal term is speculation, but it's the correct
Yes.
concept that you're trying to describe. Do you want to respond to the objection? It's calls for speculation.
Yes, Your Honor. The witness has already testified that he does recognize most of the items that he just mentioned as being items that are on previous portions of the property. So seeing that the items in question were at one point on one portion of the property and now testifying to seeing them again in the backyard, I believe it is a relatively easy inference.
Objection to the prosecutor. That is also speculation.
So I'm going to overrule the objection, but I am going to ask you to restate the question and then advise Mr. Strauss, to the extent you answer the question, you have to be specific about what you saw that had moved from one area to another area.
Mr. Strauss, what kind of items did you see in the backyard of 290 Pawnee on the 22nd of February when you came home?
Some of the items that I know have been there the entire time include, like I mentioned, a lot of the larger storage containers, the metal storage racks. I couldn't speak to kind of individual things in the pile. Some of the bins as well, I recognize.
And the items that you recognize, did you ever see any of those items on other portions of Ms. LaCompte's property?
I don't recall specific items being moved. I would distinctly recall seeing the help they have walking between the front yard and the backyard.
So you saw other entities moving items from the front to the back?
Yes.
Has Ms. LaCompte ever expressed an intention to remove these items of loose property you're testifying to?
Yes.
How many times has she expressed intention to remove any of the loose property?
Even though there was an objection, what's the relevance of that question?
Your Honor, in Boulder Revised Code section 635, which is one of the two alleged violations for today, subsection A6 includes a defense that notes to, as I mentioned before, the ability to have items be stored in a manner that is reasonably calculated for removal, testifying to the intention to have something removed and they have not been removed yet does indeed go towards negating that defense by stating that an item or in question is stored in a manner that is not being intended for inevitable removal or later repurposing.
So I think it could be relevant if we had an argument that is raised. So I'm not going to allow him to answer that question now. If Ms. Lecomte raises through her own testimony or otherwise through cross-examination the idea that she was in fact taking advantage of that defense, then I would agree that it would be relevant at that time. So I'm creating, at this point as the judge, I'm going to enter an order saying you can't answer that question, but you may be able to ask it later.
So just the question of how many times she's stated or.
Right, anything pertaining to statements that she's made about intention to move or to remove property wouldn't be relevant at this stage. It might be relevant or admissible if she raises the defense of I was planning on moving all of this property and I was taking advantage of what's set forth in section 635.
Thank you. Mr. Strauss, did you see any items be brought to Ms. Lecomte's property since March 5th, 2025?
Yes, there's a fairly regular movement of items being brought on our property.
And do you more often than not see items stored on 290 Pawnee for an extensive period of time?
Yes.
Since March 5th, 2025 today, has there been a decrease in items on the property generally?
Before you answer that question, again, from my perspective, what's relevant is what occurred or was evident on March 5th of 2025. It may be relevant if the defendant's found guilty and we're talking about sentencing, what happened since March 5th might be relevant on both sides, but at this juncture, I don't see that to be relevant.
Would you state that the storage of the items that you've seen and testified to today were stored in a manner that minimally impacted other properties?
I think I understood the question. I would argue we were fairly impacted by it.
What impacts have you personally suffered due to a large amount of loose items on this property?
We're a young family. This is the first home that we moved into. We generally look forward to liking our neighbors. We have relationships with many of our neighbors, including Ms. Lecomte and Mr. Lau. But this has been incredibly stressful. Both the sheer volume of items, like we mentioned, the risks that they bring, both wind, fire, a lot of doubt of what is there. There's a lot of exposed cables, there's heavy machinery. It has brought quite a considerable amount of stress. I would say it's probably the biggest impact it's had to us. Other than that, like I said, this is the first home we bought. It's a nice, beautiful property. It's a nice, beautiful neighborhood across from the park. But we are nervous about the value of our property, the value of the neighborhood. Like I said, some of this is visible publicly. I can kind of keep going about the embarrassment we have to sit in our backyard and have friends over for a barbecue.
And do you know of any of these, if any of these impacts have impacted neighbors down?
Like I said, I walk my dog around the neighborhood, and people see us walking off and ask us, you know, how can you live?
I'm going to stop you for a moment because the question asked for a hearsay response for him to talk about what other people might have said. So I don't want you to testify about what others have shared with you who are not here to testify today.
For the purposes of phrasing the question, Your Honor, can Mr. Strauss testify to the feelings and expressions of that others have felt due to the hearsay exception of present sense impression, seeing as it is an ongoing issue?
I'm going to pull out 801D1 real quick. And I don't believe it. My initial response is to say, no, that's not a present sense impression, but let me just pull out 801 and the exceptions under it.
Oh, sweet Jesus. What?
Am I allowed to?
Yeah, just hold for a moment while I determine
we
whether it's
can't.
admissible for you to talk about what others might have offered as a present sense impression.
Your Honor, we also believe that it would also fall into the category of an existing state of mental, emotional, or physical condition.
Hearsay exception, Rule 803 states that the following are not excluded by the hearsay rule, even though the declarant might be available as a witness. A spontaneous present sense impression, a spontaneous statement describing or explaining an event or condition made while the declarant was perceiving the event or condition. And then you've also articulated under a then existing mental, emotional, or physical condition.
No.
We'll start with 803.1.
No.
In the court's view, this type of exception is designed for someone, perhaps, as an example, a person who is walking by and sees an accident happening and they immediately say, oh my God, that person just ran a red light.
No,
They're
you
responding
can't
to
ask that.
something and spontaneously. That's different than someone who perceives a backyard and then describes it to a neighbor about how that impacted them. That doesn't relieve it from that, provided that sense of reliability that would be something which is really.
I think we know all this off the top of our head. We don't.
I'm going to again say that it's not admissible. And then let's take a look at 803 sub 3, which says a statement of the declarant's then existing state of mind, emotion, sensation, or physical condition.
Every hearsay,
but not including a statement of memory or belief to prove the fact remembered or believed unless it relates to the execution, revocation, identification, or terms of a declarant's will. Again, this provision of an exception to the hearsay rule, it comes about as a result of the drafters of these rules saying there are certain times when someone's under duress or under a mental or emotional state where they're saying something at that moment that has a certain reliability that would allow it to be admissible. And I don't think that this would fall under that either. So on either count, it's not an exception to the hearsay rule in the court's view.
Thank you. Mr. Strauss, what would you like to see happen with Ms. LaComp's backyard?
Okay, I'm going to stop you there. We're here to decide whether or not there's a violation. So although there wasn't an objection, it's a litigant who's representing herself. It's not admissible right now. It certainly could be something I could hear if the defendant's found guilty, and then we have to talk about sentencing. But from this perspective, it's just a question of whether or not there's a violation. So I'll prevent the witness from answering that question as well.
There's no more further questions.
Okay, thank you for that, Mr. Allenberg. Ms. LeCompte, cross-examination for Mr. Strauss.
Mr. Strauss, I'm really sorry that you're here, and I'm really sorry that I'm in this position as well. So I apologize to you and also to Ms. Loby. But I'd like for you to describe to me a little bit about the interaction that you had on March 5th with Officer, was Officer Cochran by himself, or were there other officers were present?
I don't recall.
So, excuse me.
Let's pause for just a moment.
You said yours? Oh, that's mine. I'm so sorry.
We'll just pause for a second. We could stop the record. Yeah, I appreciate that.
Uniform recount his own conversation.
And he's objecting, you're basically objecting that it's hearsay, correct?
Yeah.
Happy to answer.
It could become a prior inconsistent statement and admissible there, so I'm going to allow him to answer it. And if it's something that I deem I should be able to consider, then I will make it admissible. And if not, I'll indicate that it's not admissible. But let's determine if it's in fact an inconsistent statement with what was testified to by Officer Cochran.
I understand the question is, I believe, yes, we had come home. We were home on our front yard. We did see Officer Cochran. I don't recall if he engaged us or we engaged him. Either is just as likely. We have engaged with some enforcement as we've seen them before. The topic of the property, the conversation topic came up obviously instantly. Again, forget if they initiated or we did, either one's just as likely. I believe he was looking at the property.
Okay. I'm interested in the issue of how it feels to have uniformed officers come to your property and discuss things with you. And did Officer Cochran discuss this with you or both you and your wife?
Both of us went outside, but we're outside and spoke with Officer Cochran.
Was this before in the front yard, or was that later when they came? Did they come through your house?
They did.
Okay. So when they were in your house, and then I assume on your back deck and on your property, how did you feel at that with their presence there? Did you feel somewhat scared or somewhat intimidated?
We're going to object this once more for relevance purposes.
Ms. LeCompte has previously indicated that she has argued that the access to the property was in some way forced or without permission. Frankly, I don't know whether that would matter because the evidence has been provided, but perhaps Ms. LeCompte has done some research that would suggest that somehow the court can't consider evidence that has been secured in that way. So I'm going to allow him to answer the question also, so she has an answer to a question that she thinks is relevant. So I'm going to err on the side of allowing the witness to answer the question, but I'm going to rephrase it for her, which is, do you feel duress or pressured or coerced into allowing the officer onto your property?
No, and I'm happy to provide more context.
And don't need more if that's.
I would prefer to, if possible. I appreciate the apology and the regret that you have for being here. So do we. I will be clear. It is very, I don't recall specifically, but it is very likely we invited Officer Cochran in. The context is not that I feel under duress by having him in. If anything, it's the opposite. As you know, this has been an ongoing issue for quite a while. I'm here incredibly regretfully. I was hoping to come to more amicable resolution on this. No, if he came in, it was with our wholehearted, please take a photo. Please help us understand what's going on here.
Any other questions for the witness?
Do you know, Mr. Strauss, of any extenuating circumstances that might have prevented me, the defendant, from regularly interacting with you and talking with you about the issues about the backyard?
Yes, I'm aware of some medical issues that have prevented you from being able to address the issues.
Are you aware of how severely disabled Ms. LeCompte, that is me, was for the last year and almost a quarter?
I believe I am. I also believe, like I said, on February 22nd, we came home, it was help that was clearing up the front yard. I was pretty astounded to see both on that day and more recently how much was able to be cleared in just a few hours, either by yourself, by Mr. Lau, or by help. I'll even mention that I think I've offered several times to help as well. I'll take the opportunity to note there are several trailers that are constantly being loaded, offloaded. I think we're both aware there's a forklift that's been driven on a property, on the sidewalk across the street, moving enormous items. So yes, I'm aware.
Your Honor, what I'm trying to suggest is that I have not been able to interact with Mr. Lau and Ms. Lovey because of the inability basically to get around and get around.
Well, you'll be given an opportunity to testify. I can't take that testimony, that as its testimony right now because you're not sworn under oath.
Okay.
You'll have to make that decision as to whether you want to testify, but you can continue to ask questions of Mr. Strauss.
No more questions.
Anything else from you, Mr. Altenberg?
Yes, Mr. Strauss, you just stated that, with the help that was obtained by Ms. LeCompte, in just a couple of hours, they were able to clear out their entire front yard, or at least the majority of it.
I was at the hospital, my wife gave birth, but in a matter of a few days, the front yard was cleared considerably. In the last few days, the backyard was cleared quite considerably as well.
But there are still items around.
Yes, quite significant.
Now, from this, is it understandable to state that if someone dedicated time to cleaning the property, they could do it in a couple of days?
I believe so. Like I said, there's several rather large pieces.
Objection, that is also speculation.
Sustained.
Or Ms. LeCompte asked you if you knew about information pertaining to her injuries, correct?
Yes.
Was there any moving of items on or off the property within the time frame of her being injured?
Oh, excuse me, I wonder what is the relevance of that?
Do you want to object? She's objecting to your question is under relevance grounds.
Yes, Your Honor. It can be noted that one of the aspects of having these items here being removed or being stored in a manner that can permit them to be removed in any way by stating that she has injuries and she's unable to or has difficulties with moving items. We believe it's relevant to determine that if she was able to move items and the items were being moved, that they could have been moved despite the injuries question.
Don't overrule the objection. You can answer it briefly if you know the answer. And if you want to restate it for him, you can.
There's a very regular movement of items both on, off, and around property.
And this occurred around March as well?
Yes.
Thank you, sir. No further questions.
Okay. You can step down, Mr. Strauss. I know it may be a little bit inconvenient, especially on where we are on July 3rd at 4 o'clock, but there were some objections that I sustained with respect to some questions that may come up later. And so I'll ask you to just remain. You can stay outside the courtroom if that's more comfortable for you, but just if you'll remain until we're wrapped up with the evidence presentation. Thank you, sir. Any other evidence for the people?
People have no more witnesses.
Okay, so people have rested their case. Ms. LeCompte, it's now your opportunity, if you choose to do so, to put on evidence regarding this issue. I have not yet advised you of your right to testify, but I want to take the time here to do that with you. As you've heard, when we did the initial arraignment in this case, you have the absolute right to remain silent. No one can force you to testify today. If you choose to testify, you'd be giving up that right to remain silent, and you would be subject to cross-examination. And I want to make sure that you understand that. If you were to testify and take the stand and testify, if you had a felony conviction, the prosecutor could disclose that felony conviction to me. I would consider a felony conviction only as it bears upon your credibility as a witness. That means that someone's been convicted of a felony doesn't mean they're guilty of another charge, but they may be less credible as a witness. So I want you to be make sure you understand you have those rights. If you chose not to testify, I can't imply anything from that except that you've exercised your Fifth Amendment right to remain silent. Do you understand all of that?
Yes, I do.
Okay, I want to make sure you had that information before you made a decision on who to call as a witness. Do you want to call witnesses here today?
I may decide to call Mr. Lau.
Okay, so it's now your time. So did you want to call him as a witness?
I'd like to give my testimony first.
So you want to testify?
Yes.
All right, and you understand that you have the right to remain silent, but you're choosing to testify?
Yes,
Are you making that decision voluntarily today?
yes,
Is anybody forcing you to testify?
no,
Are you under the influence of any medications or drugs or alcohol that would
No.
impair your ability? I am going to find it's a free and voluntary decision to testify. If you'll come forward, I'll have you raise your right hand and swear you in. If you've got notes, feel free to bring those with you.
oh, you want me to?
Yep, we'll put you in as a witness, just as other witnesses would be. When you get up to the witness stand, you can go ahead and have a seat and then raise your right hand for me.
Oh, I need this now. It's real-time glory. This is going to be horrible.
All right, do you swear or affirm under penalty of perjury that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead and have a seat.
I got through
And
this
then,
without
Mr. Koch,
drinking
you
so
obviously
far.
don't have to ask yourself questions. You can just begin giving a narrative. It is possible that there'll be an objection, so I'll just ask Mr. Altenberg if there is an objection to stand. And then when you see him stand, if you'll pause your testimony so he can articulate what his objection is. Does that make sense to you? I'm talking to you, Ms. LeCompte.
Yes, it does.
Okay.
Sorry.
All right, so go ahead and tell me what you'd like me to know, and with that caveat in mind.
And that is the beginning of my statement.
Yes, that's right.
Okay. I would like to begin by submitting exhibits A and B, defendants exhibits A and B, at least that is how I have listed them.
Okay, let's pull up what we have marked as exhibits A and B and make sure that we're on the same page as to those. So if we can pull up exhibit A and show that.
I want to make sure that we're talking about the ones that were submitted at the very beginning.
Yeah, I think that's what we have.
Okay.
A and B were submitted well back in March or
Yes.
April.
No,
So
these were actually in April 22nd.
Objective
April,
Foundation.
is that the one that
Please
you
scroll
see
up
from
again.
April
Objective
22nd?
Foundation.
So I actually don't see anything in there until what the first things that were uploaded was on May 21st.
Why don't we pull up exhibit A that was from May 21st and see if that's to what Ms. LeCompte is discussing.
That's what we have labeled as.
That's what we've identified in our record as exhibit A. Is that what you're talking about, Ms. LeCompte?
No, it is not. Although that is actually helpful, it's not something I had planned to show.
Then I'm thinking it's the exhibit she sent earlier, then that would start with exhibit C from today.
Well, is this something, we have something that you sent in today. Did you pull up did you show exhibits A and B already?
No, this is just exhibit A that was uploaded from May 21st. I have not shown it in the.
Show exhibit B if you don't mind as well, just to see if that's any different.
It depicts the driveway and the front porch.
So there's exhibit B.
Nope, that's not it.
Okay. So-
But this does show that a lot of the materials that Mr. Strauss was complaining about have been removed.
Let's pause for a moment, though. Let's make sure that we've got what you're wanting to consider as exhibits A and B properly marked. That's what you have submitted to the court on this case. It is possible that on the other case that was previously pending, you submitted exhibits that the court put in that court file because that's the case that we were dealing with at the time. The only other exhibits we have are the ones that you submitted this morning, or I mean, perhaps last evening, which start with exhibit C. And you can pull up exhibit C, Sabrina, if you will.
Okay, actually, that is one of the exhibits that I wanted to show.
Okay. So do you want to start your discussion with exhibit C?
Okay, could I see also exhibit D?
Yes. There's exhibit C, and we'll pull up exhibit D.
Yes, okay, that's the other one.
Okay, so let's start with exhibit C, and so that if we first have to address whether they're admissible or not. So let's talk about what exhibit C is,
Okay.
when it was taken, and what it depicts.
This exhibit was taken, I believe, May 21st, April 21st, and it shows, as you scroll back, it shows the entire front porch and the driveway with all of the materials that had been shown in two of the prosecution's original exhibits. You're right.
Okay, so Mr. Altenberg, do you have an objection to the admission of Exhibit C, which has been identified as being taken on, I believe you said
April
April
22nd,
April,
first.
April 21st?
Your Honor, we have two objections to the exhibit question. The first one being improper foundation. We don't believe that it's been properly authenticated. There's no any way to mark or determine when this photo is actually taken. So we do have issues with that. Secondarily, we believe that it's unfairly prejudicial. Just because you see a photo from a certain angle, especially when trying to determine the situation of March 5th, 2025.
Also, I'm going to throw in a third objection for him. You said anything outside of March is not relevant at today's hearing. When I was trying to introduce evidence that other people said, it still sucks after that. Which is a damn good objection under the circumstances right now.
We've heard testimony already about how items are being moved around, not being removed from the property. So we do not know if this is a appropriate photo and what it may convey about the property as a whole.
These were submitted prior and accepted by the court for the hearing that was held on April 22nd. And they should be time stamped. But I don't know that they show it actually in these pictures.
Okay, so let me deal with both of those objections. The authentication, it doesn't require that it be time-stamped on the photograph. Obviously, it's more helpful to the party who's trying to admit it to convince the court that it in fact was taken on that date. But Ms. LeCompte has testified that it was taken on April 21st or 22nd. And so that lays the foundation that she took the photograph, or someone that she knows took the photograph, and it accurately depicts the area on
Thank you, Biggin.
It may not have significant relevance to my determination of what the area looked like on March 5th. And unless I have testimony from somebody that indicates this is how the property looked on March 5th, it won't get much weight at all from me. I want to make sure that Ms. LeCompte understands that. What I will be looking at today in determining whether there was a violation on March 5th is the status of the property on March 5th. So unless someone can testify that this is how it looked on March 5th, it won't have much weight as to my determination of whether there was a violation on March 5th. It may be more relevant if I'm determining where we are with respect to sentencing, if in fact the defendant is found guilty of this charge. But right now, I'm going to admit
And you're
Exhibit
guilty.
C, but it may not get a lot of weight since you've already testified that it was a photograph that was taken over a month after the alleged violation. Does that make sense to you, Ms. LeCompte?
Your Honor, at issue now is whether the conditions which prosecution has submitted in photographs on March 5th still exist.
That's not the issue right now.
Well, but
They may be to you, but let me be really clear. Right now, the only thing I have to decide is whether or not there was a violation on March 5th, not whether it's been corrected. For example, if someone were to litter on the street, the public streets on July 1st, and then on July 2nd, they came and picked up that litter, that doesn't mean there wasn't a violation on July 1st. So all the city has to establish is they have to establish beyond reasonable doubt, but they have to establish there was a violation on March 5th, not whether that's been subsequently cleared up or not. It may be relevant to me if I get to a place where I found you guilty and have to sentence, but it's not relevant for the determination of whether you were guilty on March 5th of violating the ordinance. Does that make sense to you?
yes, let me continue.
Okay, you can. So I'm going to give Exhibit C. Let's go through them. If you want to go through other exhibits, you can.
Yes, I'd like to see Exhibit D.
If we can put that up.
All
And what
right,
does Exhibit D represent?
This represents the driveway looking from the other direction and part of the front patio, and it shows the front porch patio, and it shows that the conditions that were existing on March 5th have been remediated. And I'm submitting these to suggest that the photos that the prosecution placed in evidence today, the exhibits 1 through 4, are related to the earlier charge that was filed last year. And in March, when they were taken, I was actually in the process of complying with the court's order for remediation. And as I'm arguing, by April 22nd of this year, that cleanup was complete. In fact, and that is a fact of which Officer Cochran has been well aware, that I was in fact working on the cleanup by hiring people and by relying on Mr. Lau to do much of the heavy lifting. I still cannot lift more than 5 pounds without running risk of damaging my repaired shoulders and my upper arm. So I'm arguing that I have completely remediated the conditions that were filed in the charges last year. And much of the amended charges regarding the conditions in my front and north side yards. So I have resubmitted the exhibits C and D from April 22nd. And they're part of a whole series of photos that were submitted to the court on April 22nd.
Let me pause you for just a moment there, so I'll let you continue in a moment. You want to render an objection to Exhibit D?
Is she saying that this was also taken on April 22nd?
I believe that's what I heard her say.
Yes.
We'd reiterate the same objections.
And the objection to be overruled. I'm going to admit Exhibit D again with the same caveat that I may not give a lot of weight to these because they were taken after the date of the alleged violation. But Exhibit D will be admitted, and you can continue with your narrative.
Okay. Exhibit C and D show that items are actually being removed from the opened garage and loaded on a trailer for removal.
Are you talking about different exhibits? Because I know you have them in your mind as A and B. So you got to go, you're probably talking about E and
I'm
F.
talking about the defense, the prosecution's exhibit showing the exact same space from the same location, but with a lot of items in it.
But you're still referring to the photograph that's
Yes.
up there. Okay, thank you.
Okay. So all of the items that were previously described by Deputy Reynolds as trash and rubble and other offending items had not, in addition to the photographs that have been displayed here, have been removed from the rest of the side yard and the front yard by the defendant and Mr. Lau at the time of the hearing before Judge Kahn on the 22nd. And Judge Kahn confirmed in that hearing that the photographs I submitted of each location at issue were completely clear. That's why I've submitted in evidence the 2 photographs, C and D, that were taken from the same vantage point as the code enforcement photos that were submitted today, showing that what was present on March 5th was vanished by the 22nd.
Why don't you pause for a moment since Mr. Altenberg's standing to issue an objection?
Yes, Your Honor, I would like to object for the purposes of relevancy. As before, this is over a month and a half, almost 2 months after the date of the alleged violation. We don't know how it's relevant to the actual March 5th, 2025 violation.
I'm going to overrule that objection. I'll give what weight I think it deserves as far as the testimony that's being offered here. I will just let the parties know that because Mr. Altenberg wasn't party to the last hearing that occurred with respect to the prior case, he may not have been present when we had some discussion in court as to what constituted a violation for the first case and what might constitute a violation for the second case. In the court's mind, the court had already given, as part of the sentence and subsequent hearings after sentence, had given permission to the defendant to continue to remediate the front area of the property so that she could come into compliance with the court's order on the prior case. And so from the court's perspective, any violation that's going to be established in this new case would have to be regarding the backyard area because there was already an order in place with respect to the front yard area. And although perhaps the city has a right to issue a new citation, from a fairness perspective, when the court tells a party you have until X date to come into compliance in your front yard, then the court has to abide by that and can't accept another charge relating to the front yard area. And I made that I think, clear to Mr. Reynolds and through Ms. LeCompte when we had the hearing on the other case, when I became aware that there was this new charge that was going to be issued. And
Here's
so
the
any
culprit.
evidence that I consider here today as a violation under these two new charges is going to have to pertain to the backyard area.
Thank you, Your Honor. And I'll try to be as clear as I can, Mr. Eltenberg, to explain, knowing that you were not party to all of the rest of this, and I won't try to assume information on your part. What I was trying to say is that
Yes.
it's my position that that many of the photographs submitted by the prosecution for today's hearing aren't relevant anymore because the problem has been abated, and there has been no more complaints about the front and the north and south sides of our yard, and no offending
I think it
items have been
sucks.
returned to
I'm
them.
still complaining.
So I'd also like to suggest that regarding the issue of storage of trash, none of the items defined by the prosecutor as trash were ever stored for long periods of time on my property, and they weren't intended to be. They're not consistent with the categories of compostables, newspapers, liquids, and all sorts of things listed in the city code. Most of them are Mr. Lau's personal tools, equipment, and projects. They're valuable, and they were all temporarily on the property because of rampant theft at the storage facility where they had been kept.
She's
Mr.
actually
Lau
by
was
Mr.
looking
Lau's
for a place
personal
to
tools.
safeguard them and had been actively seeking an alternative and safer place to keep them. I've earlier presented evidence in the previous hearing that the interior and the backyard of my property cannot be viewed from the street or the sidewalk because of my 6-foot privacy fence on the east side and on the north side as well, and the dense shrubs and trees on the south side. Therefore, concerns about public viewing should be dismissed. The amended motion filed by the prosecution on April 17th, which added items in my backyard to the charge, has muddied the compliance issue, and it has heightened the surveillance of the rest of my property. It's not been clear to me whether the charge on March 5th is a continuation of enforcement of the prior charge or a new one. But whatever is the case, the evidence that I've submitted in my exhibits C and D show that I've complied with the remediation that was required.
Mr. Alberg, objection?
Yes, we're going to object for the purposes of, this is conclusionary. She's stating that she is in compliance and is addressing a lot of conclusions of her sentiments if they were fact. We have not determined that.
Overruled. I'll allow the testimony, but I understand what the objection is, but I'll overrule that.
I would also like to explain that I want the court to know that I'm very sorry that the remediation process has gone so slowly. The removal would have happened a lot more expeditiously had I not been almost completely disabled for all of 2024 and the first 5 months of this year, and had Mr. Lau not suffered a very bad injury to his ankle earlier this year. The court knows that I've had 2 very serious surgeries last year to repair a shattered upper arm and replace both of my shoulders. A recovery that requires well over a year, and I'm still undergoing considerable physical therapy in order to recover from them. I have not been able to actually assist in this process at all. I have had to hire some people, and I've had to rely on Mr. Lau, whose property this primarily is, to do the removal. And Mr. Lau now is still having trouble walking, so that slowed down the process a lot more than we had hoped. I object to the use of the prosecutors 3 and 4 because they were not only taken while I was in the process of organizing and removing the items, but they couldn't have been taken legally. They were not taken from the street or the sidewalk. The issue the locations at issue right now, they were not visible from from those areas. The officer had to enter onto my property and stand right on my porch to take them. And that was done without my knowledge or permission.
Let's stop for a moment. Objection from you, Mr. Altenberg?
Yeah, we're objecting for speculation purposes. She's questioning, or it's not only speculation, but also conclusions of declaring that these photos in question were illegally taken.
I'll overrule the objection. She can make the argument that there would have to be some evidence to support it, and the court will ultimately decide whether or not there's any reason to not consider evidence.
I'm simply submitting that you cannot take a photograph of the north and south corners of my front porch without standing on the front porch, because there are large trees in front of it, big shrubbery, and you can't see it from the street. So similarly, I submit that Exhibit 5, the photo of the backyard, may well have been taken under duress from my neighbors because it was taken from their back deck. And it's a higher vantage point than is normally visible by the public. And since none of the items depicted in these photographs can be viewed either from a sidewalk or the street by the public, they should not have been entered into evidence. So, in summary, I have been very distressed by the inability to make this all happen faster. I wish that my recovery had been faster. I certainly have been trying. I wish that the injury hadn't happened to Mr. Lau, but I would like the court to understand that I have been doing my very best to get this done, and that I have been, to the best of my ability, complying both with the original charges and the compliance plan. And I have also been working hard to do the rest of it. I'd like now to show the last exhibit that I have, which is, I believe it would be
We probably have, next would be RE, so why don't we pull up Exhibit E, and then we can do Exhibit
Okay,
F.
so this is the one that
I accidentally pulled up Exhibit F first.
Hold on a second, that was F, so she's pulling E up now for you.
No, all right, so Exhibit F, please. I'm sorry, the previous one that showed the yard.
It's just taking a moment, man.
Yeah, that one.
All right, this is Exhibit F.
Okay. If you continue to scroll back, this is the south side of my backyard, and it is comparable to the Exhibit 5 of the prosecution. And it shows that all of the items that were taken, that were photographed from behind my fence, from the neighbor's yard, are gone on this whole south side of my property. And that was submitted yesterday.
Okay. Any objection to the admission of Exhibit, that's Exhibit E?
Yes, Your Honor. More than anything, it's definitely like a foundation. She's submitted it yesterday. We don't know when the photo itself was taken.
Do you want to testify as to when that photograph was taken?
This photograph was taken yesterday, and it was submitted in the morning, and it was submitted in the evening.
Any other objection?
We're going to object for relevancy purposes. This is 4 months after the date of the alleged violation.
I'm going to allow Exhibit E. As I said with the others, unless you say this was, and you've already indicated it was taken yesterday, unless you say this is the state of the property on March 5th, it won't be given any weight to me by me in determining whether you're guilty of a violation on March 5th. It may, unless you have testimony to offer that, whatever weight is going to be very minimal because it doesn't show what the property looked like on March 5th.
Your Honor, I would submit that the backyard was actually added to the condition of the backyard was added to this as of March 5th. And it would have been impossible for me to immediately clean that up. And for all the other reasons that I have stated earlier. And therefore, I apologize, I've got allergy problems.
Let me just be clear as far, I'm going to admit Exhibit E, but may not give it much weight at all, depending on the testimony that comes in.
Your Honor, technically this is Exhibit F,
Oh.
actually. This is the final one. I just want to make sure.
Oh, okay. I thought I've got the, so this is Exhibit F. This is the photograph here. This is Exhibit F.
Yes.
I'm going to admit Exhibit F, but may not give it a lot of weight since it's been testified that Exhibit F was taken on July 2nd. All right. Do you have any other testimony that you'd like to offer, Ms. LeCompte?
Well, I'd simply like to submit that I am confused and puzzled because I thought the objective was to get the property cleaned up. And when I am showing pictures that show that, in fact, they have been cleaned up and they are in the process of being cleaned up, and then show documentary evidence, I'm sorry, I did not realize I had to have them notarized or something like that
You
to
don't.
prove.
You do not.
But I'm sorry, I'm being a little sarcastic. But I am confused by the fact that showing evidence of such compliance is then considered to be irrelevant. And with that, I have nothing more to say right now.
Okay. Thank you for that, Ms. LeCompte. Any cross-examination, Mr. Altenberg?
Just to confirm, Your Honor, any questions pertaining to actions taken after March 5th will be taken into account for sentencing purposes if you find.
And frankly, I would prefer to have those occur if in fact there's a guilty finding. I haven't gotten to that stage yet. So I would prefer any testimony to be about the status of the property on March 5th or before.
We have no further questions.
All right, then you can step down then, Ms. LeCompte. And then, Ms. LeCompte, you said a few minutes ago before you took the stand, you weren't sure whether you were going to call Mr. Lau as a witness. Have you decided whether you'd like to call him to testify? Keeping in mind that what's relevant to me at this stage of the proceedings is the status of the property on March 5th. So if there's testimony that you want to offer from him that has to do with other dates after March 5th, it won't be relevant to me. So I want to make sure you understand that.
Oh, no,
I understand that, Your Honor, but I also then have to say that I was sincerely confused
Yeah, we know.
the issue of March 5th versus the cleanup
Okay.
and which was
No,
most
noted.
relevant. I have focused on the fact of getting the property into compliance with the code and have been unaware that I was then being held to a violation only for what
Ma'am, are
was
you a
on March
whore?
5th. And I don't want to get called Mr. Lau.
Okay. So any other, then I'm assuming that you're resting your case. Is that correct, Ms. LeCompte?
I will be giving a summary.
Well, yeah, closing statement you'd like to
So
make? Yes, you'll have the
loud.
opportunity to do that. So defense has rested her case. Any rebuttal case that you need to present, Mr. Altman?
For the purpose of the March 5th incident.
All right. And did you want to step out and let Mr. Strauss go, or he can remain? But we're turning to closing arguments then. And if he wants to remain, he can come back in the courtroom. He can stay outside the courtroom. He can also leave because he won't be recalled.
And,
Okay for another 10 minutes.
How long did he say? 10 minutes?
Go ahead.
Your Honor, the people have proven beyond a reasonable doubt that Ms. LeCompte is guilty of violating Boulder Revised Code Section 633, the accumulation of trash, recyclables, and compostables prohibited, and of violating Boulder Revised Code Section 635, storage, disposal, and screening of trash, recyclables, compostables, and other and specified other materials. Both provided through testimony today by the city's two witnesses, both Officer Benjamin Cochran and Mr. Jason Strauss. And in the exhibit shown today, it is clear that on March 5th, 2025, there was a plethora of loose property that had accumulated in the backyard and property of Ms. LeCompte. Not only did she store these items throughout her property, they were described by Officer Cochran as junk, had accumulated over the course of some time up to March 5th, 2025, during which Ms. LeCompte failed to dispose of it and had not put the items in a manner or organized them in a way that made them clearly available to be disposed of or reused another time. Not only were many of these items visible to the public, but there were also plethora of dangers of which we've been testified to today that Ms. LeCompte did not express any worry about. Mr. Strauss testified to his extreme worry about how both the storage method and the items themselves, especially in the backyard, constituted an extreme fire risk, that they harbored animals, rats, rodents, mosquitoes, raccoons, that there was odors that did percolate from the backyard, or at least from the property, and that these items included large containers of unknown liquids that were visible from the public. The evidence provided today shows a clear contradiction to compliance of Boulder Revised Code Section 63A1, 633A2, 633A3, 65A1, 65A2, 65A4, 65A5, 65A6, and 65A11. Your Honor.
633, what were the two subsections that you were suggesting under 633?
633A1, 633A2, and 633A3.
Okay, you can continue. Thank you.
Your Honor, the requirement that the items be visible to the public is only established in Boulder Revised Code 633. Although there are many items that may have been established to be somewhat difficult to see from the public point of view, including the backyard, 635 does not have that requirement whatsoever. It simply talks about the aspects in which the items in generally are stored upon the property of an owner or an occupant of the property. The frustrations and pains of Ms. LeCompte's violations are clear, but despite them, on March 5th, 2025, she nevertheless still had those items on her property and in her backyard. The people ask that you find Ms. LeCompte guilty of violating Boulder Revised Code Section 633 and Boulder Revised Code Section 635 and sentence accordingly.
Thank you for that, Mr. Hollenberg. Closing statement from you, Ms. LeCompte.
I'd like to begin by saying that as the court really knows that both I and Mr. Lau have been hampered by injuries and surgeries, and in being able to accomplish this removal as expeditiously as we would like to. And I cannot lift more than 5 pounds myself without risking damaging my repaired arm and my shoulders. But as I've previously told the court, the materials at issue in this case were primarily Mr. Lau's tools and equipment that he regularly uses, not trash. None of the materials or the items that are enumerated or complained about fell under categories like standing water.
Today, Your Honor, my health is in jeopardy right now.
What's that?
I have IBS.
Back of the yard, because in fact you can't see them either from his fence or from his yard or from the street. And the only standing water in my backyard is a bird bath. It's a large bird bath, but it is still nonetheless a bird bath that is cleaned regularly. The other barrels are plastic food grade barrels that are turned over or turned upside down so they cannot contain water.
Got a placenta in
As
there?
I've also previously told the court, they were not stored there permanently. They were there temporarily because of the rampant theft at the storage yard where Mr. Lau had kept them. And he was seeking new space for the storage and actually has succeeded in rehoming most of it. The evidence presented has documented that all the offending materials related to the first charge filed, dealing with items visible by the public to in the north and side in the north side and the front yard, were removed
We have not.
From the property by
But we
April
have suspicion.
22nd, and I've provided photographic evidence of that. The court ruled that I was in full compliance with that remediation. I have earlier presented evidence that the interior and backyard of my property can't be viewed from the street or sidewalk because of the 6-foot privacy fence on the east side and the higher fence on the north side and the dense shrubs and trees on the south side. So concerns about public viewing should be dismissed. The amended motion.
So what's the objection, Mr. Altenberg?
Your Honor, this is new testimony about the ability to see into this Lacoste backyard due to the sizing of fences and shrubbery that blocks view.
I'm sorry, I did testify to that in my statement.
And I'm going to overrule it because she could be arguing about, she can be making argument, and it's up to me ultimately to what testimony I heard, but she could be making argument based on the pictures that I have. So I'm going to allow the summary closing on that point. I'll give what weight I determine appropriate to it.
The amended motion that was filed by the prosecution on April 17th, which added items in my backyard to the charges, has actually heightened the surveillance of my property, and it's muddied up the waters because it's not clear to me whether the charge on March 5th is a continuation of enforcement of the prior charge or a new one. And whatever the case is, evidence that I've shown shows that I've complied with and I am complying with the remediation required. And I've shown in the exhibits that I've shown that the materials presented in prosecution's Exhibit 5 have been removed completely. I've also objected to the use of prosecutors' evidence, Exhibits 1 and 2, because they depict materials that are being loaded at that time on March 5th for removal during the compliance process. I objected to prosecution's Exhibits 3 and 4 because they show that on March 5th, there were materials already being loaded for removal. And because they were taken by accessing my private property right on my front porch without my permission.
Let's pause for a moment just so Mr. Altenberg can raise his objection.
We're objecting once more for newfound testimony, Your Honor. At no point did Ms. LeCompte talk about how that on the March 5th date, the items in her front driveway were being used for removal purposes.
I'll sustain the objection to that point, but I'll just remind the parties, the front part of the property is not the issue for the court. The only thing that I can find the defendant guilty in the court's mind is what's contained in the backyard area. So Exhibits 1 through 4, which depict the front yard, were admitted without objection, but they're not what I'm going to be relying on to determine the case.
Well, once again, I have been confused about, and I have focused on the entire property instead of simply the backyard because all of this has not been clear to me. And with that said, then I also object to prosecution's Exhibit 5, taken as it was by, I believe, subjecting my neighbors to duress as told to me by Mr. Strauss's wife on the 11th of June, 11th of May.
Mr. Altenberg has an objection to that statement.
Once more, Your Honor, this is a newfound testimony. At no point did Ms. LeCompte note anything involving a conversation with Ms. Lovey and a statement involving express duress involving the interaction between Ms. Lovey and Officer Cochran.
I'll sustain that objection.
Right,
There wasn't evidence presented during the trial about any conversation between you and Ms. Lovey. So that's sustained.
It was very hard for me to figure out how to fit that into these arguments. I do have a photograph demonstrating that conversation, but I submitted it in evidence, but I haven't.
You didn't lay any.
Submitted the photograph.
You didn't lay any foundation for admission, nor did you offer any testimony.
Sorry, that is my misunderstanding of trial practice.
Yeah.
In any case,
You also closed your case.
photograph in Exhibit
Shut up.
5 used my neighbor's property as a higher vantage point from which to take the photograph of a yard the photograph that otherwise is not visible from the public. All of the remaining items in the backyard are Mr. Lau's tools and equipment. He is diligently removing all of them, awaiting only the availability of storage space in the near future. He's been hampered by his injury and also by preoccupation with other legal matters involving Officer Cochran. The only items that will remain in the backyard
And
are
generalized
gardening
stupidity.
equipment, patio furniture, barbecue pits, bird baths, a bicycle, normal outdoor activities. And in summary, given the lack of evidence in some areas, the lack of what I feel is unlawfully obtained evidence in others, and especially given
We don't care what
the
your
proof
about your
of my
feelings.
compliance with remediation,
Not a bit.
I ask the court to rule in my favor. Thank you.
Rebuttal close from you, Mr. Altenberg?
I'm sorry?
I was asking Mr. Altenberg if he has a rebuttal close. He has the burden of proof, so if he had any final comments to make, he would have the right to make those.
Yes, Your Honor. As noted by Ms. LeCompte, there's a statement that the items in her backyard are not trash. In fact, they are instead items, tools, projects for Mr. Lau. Let it be reiterated that to be found in violation of BRC 635 at least, one aspect does simply state that stored brush, fence post crates, vehicle tires, vehicle bodies or parts, bed mattresses or springs, water heaters, or other household appliances damaged or stored, or discarded furniture and other household goods or items, materials recovered from demolition, and other stored items discarded, objects 3 feet or more in length, width, or breadth. Even if the items in question that we saw today were tools or projects or other aspects like that, we've proven beyond reasonable doubt that those items indeed fall into this category here. And furthermore, Your Honor, it was further noted that indeed the backyard fence is around 6 feet, but you heard testimony today from Mr. Strauss, who did testify that even if you were up against the side of the fence at the exact 6 foot mark, you could still see the pile of items on March 5th from over it. And therefore, he noted as well that you could see it from other portions of the property and from the public view as well as he walks his dog and has his child ride his bike. Your Honor, we do indeed find or request that the court find Ms. LeCompte guilty of violating both Board Revised Code Section 633 and 635.
Okay, I'm going to take about 5 to 10 minutes. Sabrina, I think if you.
Or what?
Okay, I need about 5 to 10 minutes to get my thoughts together so I can address both of these, and then I'm going to come back and give an oral finding on both charges. So
Oh my
you all can relax. If you need to
God.
run to the restroom, give me a few minutes and I'll be back. Okay, we are back on the record on the LeCompte case, which is case number 2025-1045. The testimony and presentation from both parties was very helpful today, and I appreciate that from both sides. I did take a few minutes to review the evidence that's been presented. And as the parties understand, there were 2 charges that were brought here. A violation of section 633 of the Boulder Revised Code, which is the accumulation of trash ordinance, and a violation of section 635 of the Boulder Revised Code, storage, disposal, and screening of trash ordinance. Both of them alleged to have occurred on March 5th of 2025. The evidence in this case comes from basically 3 different sources. First, we had the testimony of Officer Cochran. I found Officer Cochran to be very credible and believable. There was also, well, actually 4 sources. There was also the testimony of Mr. Strauss, who was a neighbor to Ms. LeCompte. I found him to also be very credible and believable. Ms. LeCompte testified, and I found her to be credible and believable as well. And then we had some exhibits that were introduced. Most significant in the court's mind was the People's Exhibit 5. That Exhibit 5, which was taken on March 5th of 2025. And if we can have Sabrina just pull that up, I want the parties to see that so that I can address what I see in that photograph. But it was also testified to what was in that photograph by both Mr. Officer Cochran and by Mr. Strauss. And it's very clear to the court's perspective that there is a large amount of what the court would consider an accumulation of some property, but primarily what the court would consider to be trash. And that term is defined under section 611, I believe. 632 actually is what it is. Maybe it's not under section 632. Can't get my cursor to stop right on trash. There we go. Trash means any solid or liquid waste, whether combustible or non-combustible, includes without limitation garbage, rubbish, rubble, refuse, industrial waste products, brush, fence posts, crates, vehicle tires, vehicle bodies or parts, household items, organic material, animal or vegetable waste resulting from the preparation, cooking, and serving of food, paper, ashes, cardboard, cans, broken glass, cups, pieces of paper, plastic, yard clippings, wood, branches, twigs, glass, rags, and wearing apparel of any kind. That's a very broad definition of the term of trash. And if you look at the items that are contained in Exhibit 5, there are a large number of household items that are treated by the way that they're laid out in Exhibit 5 is clearly constitute trash in the court's mind. There was testimony both from Mr. Strauss and from Officer Cochran that would support that conclusion that what is in the backyard in photograph of Exhibit 5 is clearly trash. So there was an accumulation of both property and trash in the backyard. The other part of Section 633 of the Boulder Revised Code requires, at least under Section A1, that it be visible to the public. Mr. Strauss testified that as he walks by that property every day, he's able to see that. Maybe it's through looking through the fence posts but it is from the public right of way when he walks along that sidewalk, is able to see that trash that is accumulated there. So it is visible to the public. Perhaps not as visible as what was on the front porch or in the driveway of the property to the public, but still visible to the public. So under Section 633A1, the court is convinced beyond a reasonable doubt that there was a violation under that section, and I will enter that finding today. Under Section 635 of the Boulder Revised Code, it's a similar provision. It doesn't have the requirement under Section 635 that it be visible to the public, but I am going to go through that briefly so that I can describe my findings in that. Section 635 A1 says, no person shall store trash, recyclables, and compostables except in containers in a manner so that they are not overflowing. And then it goes on from there. But clearly, based on what I've just found on Section 633, under Section 635, again, there was a violation of this accumulation of trash and property in the backyard constitutes a violation under Section 635A1. There was some discussion by Mr. Altenberg with respect to other provisions. I would point out that under Section 635A6, the storage of various items, including household goods, also can be a violation unless they're reasonably calculated to prepare them for collection. And the way these are laid out in the backyard, they're not being stored in a way to be prepared for collection. So I will find that under section 635A6, there's a violation. And then under section 635A11, that talks about a storage, it's unlawful to store trash, recyclables, or compostables in such a manner as to constitute or create a fire, health, or other safety hazard or harborage for wildlife or pests. And there was evidence presented, although not entirely convinced about the pests argument, that certainly that there does create a fire hazard and a hazard to the health and safety of others, because this is a windy community, and these large amount of items that are stored in the area in the backyard could certainly be moved by wind and could create a hazard in particular to Mr. Strauss's property, which is immediately to the east, which is to the east of that fence that we see where the property is located on 290 Pawnee. So for all of the reasons I just described, I am convinced beyond a reasonable doubt that the defendant violated section 633 and section 635 of the Boulder Revised Code. There were some arguments that were raised by Ms. LeCompte that I want to address. The fact that she may have suffered some injuries and had removal was difficult. I recognize that. The code does not offer a defense as to someone's ability to remove property. It's required if you are an occupant of property, whether you are a tenant or a landlord or an owner of property, to maintain compliance with these ordinances. And although on occasion people's physical disabilities or limitations can make it difficult for them to comply, it's not a legal defense to complying with the statute. The other argument that was raised with these were not permanent, but they were there temporarily. That's really belied by the statement that was made by Mr. Strauss that it had been there for long periods of time. And in particular, he recalled on February 22nd and forward that these items were on the property and that they remained there on the property for some period of time. That belies the idea that this was not a permanent storage area. Some people's definition of permanent might be different than others, but from the court's perspective, being there for 3 or 4 weeks is not a temporary location of items in the backyard. And then finally, the idea of the duress of the neighbors that Ms. LeCompte testified to. That was the only place where I found it somewhat incredible to hear, because she heard Mr. Strauss very specifically address the court and say this was not under duress. And in fact, it was welcomed to have the officer come on the property and take a photograph so these issues could be resolved. So there was no establishment in the court's mind that there was any duress in the taking the photographs. I'm not sure how that would play out legally, even if I did make a finding of that. But those photographs were lawfully taken and showed very clear that this photograph, Exhibit 5, was lawfully taken and clearly showed the state of the property on March 5th. And I also have the testimony of Officer Cochran establishing the same. So I just wanted to make sure that I'd address that. And then finally, I want to point out that this was the state of the property on March 5th. So I have found the defendant guilty of that. She's offered some evidence that could be considered if we in a sentencing hearing, which I will have on another date, because I don't want to keep our security officers here down the hall, nor do I want the parties to have to try to prepare for a sentencing hearing right now on the fly, because it is relevant to me, Ms. LeCompte, what you have done since March 5th with respect to the property. And so that will be taken into account in sentencing. And I want to give both sides an opportunity to prepare, because if I've at a sentencing hearing am convinced that there is no longer an issue there, it won't mean that you weren't guilty of the violations from March 5th, but it'll have a dramatic impact on what I impose as far as sentence going forward. So what you've provided to the court is not completely without merit for me to consider at some point. It just can't be considered at this stage of the proceeding, which is how the state of the property was on March 5th. So I want to assure you that's still important to me, and give you the incentive, if there are remaining things that need to be cleaned up, that it will be significant to me, the state of the property at the sentencing hearing. So we'll do that on another day. And both you and Mr. Lau are certainly welcome to participate by coming in person. But if you want to come via Zoom video, if that's more convenient for you, or if you want Mr. Lau to appear by Zoom video, that's perfectly fine as well. And same for you, Mr. Altenberg. If you have witnesses that you'd like to just participate in this hearing, the sentencing hearing by Zoom video, that's fine with the court. Do we have some dates? I'm thinking just a few weeks out, but obviously on my calendar, maybe 3 weeks out, so that we can I'll give a little bit more time if there's last minute things that need to be addressed, and that gives the prosecution an opportunity to have Mr. Cochran or someone else go over to the property and take a look.
Just for this purpose of scheduling the hearing, I myself will be unavailable the week of Thursday, the 24th, Friday, the 25th, and Monday, I believe the 30th. The 24th and 25th and the 28th of July.
Okay, so let's schedule it after July 28th. Let's pick a date and time. And if you chose a date, I don't have any dates that I'm not planning on being here. So even if Judge Hill is on the bench, I can come and do the sentencing. So we've got a good amount of flexibility, but we're looking at that week after July 28th.
And we would actually technically just put this on a hearings docket, so to speak.
I think we should put it on a hearings docket rather than take a trial slot, because
Exactly.
it might take a full hour for us to really go through things. And
Understood.
if that makes sense to you. Like, and you could even take those jury readiness conference slots. Well, the 28th may be the city of Boulder has, I think, something going on that day. That's from 11 to 2, if I remember correctly.
Mr. Altman won't be.
Oh, the 28th he's not going to be here. So we're looking at maybe the
4th might
4th
be
of August.
Yeah, might be the first one. It could be at 8:15. And I can look at jury readiness conferences too right now. I just have those.
So we could do 8:15 in the morning, which might be a little early for the parties. I don't know, but the 8:15 is certainly an available possibility on August 4th. We could also do something in the afternoon of August 6th at 3 p.m. We could take those jury readiness conference slots because there's nothing else scheduled. Might have you get rid of the other JRC slots so we wouldn't have to worry about competing with other cases. So August 4th at 8:15 or August 6th at 3 p.m. And this is just.
Either one is fine for me.
Okay, Mr. Altenberg, do you have a preference of either of those?
No, yeah.
Why don't we make it to 3 p.m. on August 6th? And then we have, I think, plenty of time, because then we have we would have a 9:30 that might clash with us on the 4th. So let's make it the 6th at 3 p.m. If you slot it in there, then eliminate the other, or I can eliminate the other position. You probably can't go in. I'll go into scheduling and eliminate the other. So nobody comes in and sets something else at the same time. I just hate to do that when we want to take adequate time on this. All right, so we'll schedule this for August 6th at 3 p.m. Everyone who wants to appear in person can, or can appear by Zoom video if they choose.
Somebody
All
remind me.
One clarification based on what you said. From today onwards, there may be additional inspection or whatever. Would those constitute a new charge, or would those satisfied because evidence is based on from March 5th to today?
The ordinance, Mr. Lau, provides that the city has the authority to issue a citation for every day of a violation. That doesn't mean that they will. I can't tell them not to go and issue another citation for the state of the property. I can tell you that from my perspective, what I'm going to be focusing on is what the property looks like when sentencing occurs versus what it looked like on March 5th. And so if there isn't a new citation, that will be all that I'm doing. I can't tell the city that it can't go and issue another citation for a property that remains technically not in compliance. And I'm not issuing an order at this point that they're prevented from doing that. I would doubt it. I think they're probably, my guess is they're probably done, but it's not up to me to say. And so each day someone could issue a new ticket. They could have gone on March 6th and March 7th and March 8th and issued a new citation.
Your Honor, I've learned that from parking. Thank you, Your Honor.
You're
But
welcome.
however, if the city should decide to present new citation and so forth, that would be considered a new case, or would defendant have the opportunity to offer evidence to counter that?
It would be a new case, and she would be presumed innocent of that case, just like she was in this one, and then would go forward with another process.
Thank you, Your Honor.
Yeah.
For clarification.
All right. Anybody else have any other questions?
Yes, Your Honor. For evidentiary purposes, for the hearing upcoming on the data is evidence proposed today and statements made during today's trial Are those eligible to be used during the hearing?
You can comment on anything that's been offered during the trial, because that's why I wanted to stay on this, because I will have heard that testimony. So both of you can comment on evidence that was brought forth during the trial. That's always relevant in sentencing. And any photographs that were admitted during this case would be something that I can consider at sentencing as well, but also photographs or testimony as to the state of the property on the date of sentencing or shortly before the date of sentencing will be relevant to the court.
Thank you.
Yeah, you're welcome. Thank you all for appearing, and have a good 4th.
Ah, there you have it. Guilty as sin. Guilty, guilty, guilty. Burn the witch. He won't do anything. He won't do a damn thing. She'll come in with some doctored up photos and be like, oh, it's all good now. And the judge will be like, well, don't do it again. That's what we're in for. That's what we're in for. Get yourselves ready, people. I still say we should have gone with my initial plan. Dart, remove, JDAM, bulldoze. That's it. We would have this all fixed by now. Thanks for coming out. I'll see y'all soon.